Morning, everyone. I'm just waiting on Ms. Hart's audio to connect. Okay, it looks like everyone's audio is connected and we have everyone present, it appears. Good morning, I'm Judge Blake Adams. We're here for the small claims non-jury trial docket this morning. The case we have on the docket for today is Kenneth Karasik and Nancy Smith v. Sandra Hart. Let me start with the plaintiffs, if they could introduce themselves. Is Mr. Karasik or Ms. Smith present?
Yes.
All right. And could you just state your name?
Nancy Smith.
Thank you. And is Mr. Karasik there?
He's not with me. He should be on another phone line.
Okay, we don't have him yet. I don't think, do we? And it looks like we have Mr. Green. Good morning. And Mr. Green is here on behalf of Ms. Hart, who's present. I do have someone else in the courtroom whose profile name is Boyd E.R.
Can you hear me now?
Yes, I can hear you.
All right, great, thank you.
All right, is this Mr. Karasik?
It is.
All right. And then I've got another person in the waiting room whose profile name is Ralph Epifanio. Is that a witness for someone?
Not for me.
Mr. Green?
No, Your Honor.
Okay. Let me bring that person into the room. Good morning. Let me call on the person whose screen name is Ralph Epifanio.
That's me. Can you hear me?
I can hear you. Can you hear me okay?
Yes, I can.
All right. And what case are you here for?
I'm at 10 o'clock. I'm the defendant, ESK LLC, against Christopher Lewis.
Okay. All right. If you'd like to come back at 10 o'clock, that would be great. We have another case ahead of you.
Okay. So I'll go off now.
All right. Thank you.
Bye.
All right. We'll see you back at 10.
Okay.
Okay. First, before the non-jury trial, we do have the plaintiff's motion to grant summary judgment, of which an objection was filed against. Mr. Karasik, I'll let you go first on your motion for summary judgment. Let me go ahead and swear all of the parties in. If you'd raise your right hands to be sworn. Do you swear or affirm that the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
All right, thank you. All right, and while I have Mr. Karasik go first, or Ms. Smith, whoever would like to argue the motion for summary judgment, if I could have everyone else mute their microphones Obviously, Mr. Green, if you have an objection, you can jump in. So I'll turn it over to Mr. Karasik or Ms. Smith on the motion.
It'll be me, Judge. Ken
Okay.
Karasik. One question, when you said there was an objection filed to the motion for summary judgment, are you talking about the affidavit signed by Ms. Hart? Because that's all I have. I don't have a formal objection of any kind.
Yes, that's what I'm referring to.
Okay, thank you so much. All right, well, the motion for summary judgment really is pretty simple. This case is a non-disclosure based on Johnson v. Davis, which is the landmark case in Florida for disclosures. The three issues that need to be decided for the plaintiffs to prevail are, number one, that the plaintiff or the defendant knew of the defect, failed to disclose it, and second, that it was not observable to the seller or the buyers, readily observable, and that it materially affected the value of the home or whatever was being purchased. Here, obviously, the air conditioning unit is located in the attic, not observable to plaintiffs unless they were to crawl up there. And so I think number two has been satisfied. Three, replacing the air conditioning and the ductwork at a cost of over $10,000 certainly materially affects the ability of the home. So really the only issue, as I indicated in my motion, was whether she knew about the defect in the air conditioning unit. The court has copies of invoices for service orders. The main one, the first one, was telling them, that was her and her husband, that there was truss design severely limited the ductwork and that it wasn't sufficient to cool the house. Ms. Hart's defense was that she never saw that invoice and therefore she did not know about it. She goes on in her affidavit and says that all the invoices after her husband died, she signed, and but was never aware of any problems. I think that that's pretty hard to comprehend under the circumstances, and I'm sure the court has reviewed some of the service orders and some of the estimates that we had. Every one of the estimates says that the temperatures varied from 8 to 10 degrees in the home. And so what Ms. Hart is telling the court and myself is that the master bedroom where she lived and slept, I assume, with her husband for 3 years before he passed away, there was never any conversation about, geez, it seems a little bit warmer in here, nothing. And then even afterwards, because we came to the house to purchase it, and after 3 minutes in the house, we asked what was wrong with the air conditioning, and she said, if need be at the trial, that she kept it, she wasn't staying there, so she kept it at 80 degrees. That being said, her affidavit, and the main reason for this, and we could probably shorten it, is that at the pretrial mediation, Ms. Hart talked about—
Objection, Your Honor.
Yes, go ahead, Mr. Green.
Those would have been statements made at mediation.
So?
At mediation?
Yes,
All right.
Your Honor.
Sustained. You can't talk about things that are talked about at mediation.
Well, I guess I can question her when she gets on the witness stand if we have to do that. Anyway, I can go on with the fact that the other things that she talked about in her affidavit, the fact that she provided an invoice from, I think, Whaley's, that the air conditioning unit was checked in March and was operating at that time is really irrelevant, because it wasn't operating for the purpose for which it was intended. It would kind of allude to the comparison if I get an EKG and it's fine, and then I could drop dead of a heart attack 2 minutes later, because at the time they did the EKG, my heart was functioning. But if there are underlying problems that weren't aware with a cursory inspection, then obviously that's a situation. The defense about as is, I think the court's well aware, and I think I have the case. It's I think where they said that as is not an excuse, it does not excuse a disclosure question under Johnson v. Davis. So the other things that she alluded to, and again, I guess we will get to it one way or the other, but she talks about in her affidavit, she was unaware of any problems with the air conditioning or the duct system. But again, for 7 years, not knowing the difference between 8 and 10 degrees in the summer in Florida is pretty hard to comprehend. The other thing is that on the disclosure statement, there are three boxes checked: yes, no, and I don't know. If Ms. Hart didn't know about anything, she could have checked that box. I don't know. She didn't. She checked the box no. Other than that, she also did not provide us with any of the information until after the home was purchased. So she had all these documents that she claimed she didn't know about, didn't sign, didn't hear, but never provided them to us until after the purchase of the home. So, and I think what's really telling here, Judge, and again, we have a different attorney here than Mr. Sott, who was at the mediation. And I think we may get to that. There obviously is a reason why Mr. Sott is not representing her at this point in time. But because you sustained the objection, I guess we'll have to proceed to the trial if they don't grant the motion. But again, in the motion for summary judgment, as I alleged, and there may be another objection, that she talked about the trust design with neighbors.
Yes.
He's again referring to statements that were made at mediation.
All right, sustained.
Okay. Well, I guess we'll just have to allow you to make a ruling on the motion for summary judgment, because the motion really was based on what happened at the mediation. So I guess we can ask her the questions when she's under oath at the trial if you choose not to grant the motion.
All right. Thank you, Mr. Karasik. Mr. Green, any response?
Briefly, Your Honor. Statement of claim that was filed by the plaintiffs states that there was a failure to disclose a defect in the air conditioning ductwork. And it says, see attached. On home purchase, defendant made aware of problem in 2013. That is the entire statement of claim. The 2013 invoice that is attached to the statement of claim states that ductwork is undersized but severely limited by truss design. Okay. Also attached to the complaint is the disclosure upon which he bases his claim, which asks the following question: are existing major appliances and heating, cooling, mechanical, electrical, security, and sprinkler systems in working condition, i.e., operating in the manner in which the item was designed to operate? Those are the only two attachments to the statement of claim. In fact, I think Your Honor can grant summary judgment because the 2013 invoice states exactly that it's operating as it is designed. Makes a criticism of the design, but states that it's operating as designed. That's the standard property disclosure from the Florida Realtors contract. And it's written that way: operating in which the item was designed to operate. In addition, Ms. Hart has provided the affidavit in response that states absolutely she had no knowledge. She wasn't even aware of this 2013 invoice. Her husband dealt with that before his death a couple of years after that invoice date. She only saw it for the first time when the statement of claim was filed. But even if she had been aware of that invoice, Judge, again, it only states that the system was operating as designed. But she did not see the invoice. She never had conversations with her husband. She was never told by anyone that the ductwork was undersized by design. Never went in the attic personally during her living in the home. Again, her husband passed in 2015, and prior to 2015, as her affidavit indicates, he handled everything with regard to air service, any other thing at all. Attached to her affidavit, as the plaintiff pointed out, is an invoice from Whaley's Air Conditioning. And this was some 3 months prior to closing, 3 or 4 months prior to closing. And it states the same thing. Everything running to design at this time. Okay. And now the plaintiff submitted as exhibits 7 or 8 other routine maintenance monthly air conditioning invoices that simply state routine, had to replace the flux capacitor, or, had a fuse out, or check the unit, it was good, pumped this or that. What you typically get when you have a monthly service contract. So really the only invoice at issue is this 2013 invoice. And that's the basis of the claim. And it states that it's running as designed. And then another invoice a few months prior to closing. It's running as designed. The disclosure states, is it running as designed? Again, we didn't file a motion for summary judgment, but Your Honor is aware that you can grant summary judgment in favor of the opposing party on a motion for summary judgment, in this case by the plaintiff. We would request that you do that based on this evidence.
All right.
Judge, can I respond briefly?
You may.
Thank you. What the other attorney has said is not entirely true. Ms. Hart signed 7 or 8. They were not routine maintenance. A couple of them said no cool. A couple of them were done like 5 days apart, which would certainly indicate that there was some issue. And it's hard to believe, again, we can't read people's minds, but to have no discussion when you're out there on service calls several times, signing those things, but claiming you never saw the other ones is somewhat, alarming. The other thing is the things that we attached regarding the estimates said, when people reviewed it, said that there was a history of problems with the air conditioning unit. And to me, and I guess it's a matter of how you word it, operating as designed, an air conditioner to me is designed to cool the home or wherever it's at. If it's not operating to cool the home, then it's not operating as designed. Here, it was not operating as designed because the day we moved in, it collapsed because we turned the thermostat down to a reasonable temperature so the home would be cooled. And when we did that, the very first day, we had to call repair. So I think that that's kind of not a basis for any summary judgment for the defendant. And I think we just, I guess, need to have the trial and ask some questions that need to be answered.
All right. Anything else from you, Mr. Green?
No, Your Honor. I just urge you to read the statement of claim.
All right. And I have read the statement of claim, and having heard arguments from both sides, I'm going to deny the plaintiff's motion for summary judgment. I do believe there may be some genuine issues as to the material facts in this case that we will need to hear. So I'm going to deny the plaintiff's motion for summary judgment as well as the defendant's or tenant's motion for summary judgment. All right, with that said, are both sides ready for trial, or would you like an opportunity to reach a settlement agreement?
We are ready for trial, Your Honor.
Okay.
We're ready.
All right. I've already put everyone under oath, and do both sides wish to waive opening statements? I kind of feel like the motion for summary judgment served as opening statements, but I'll give each side an opportunity if they wish.
Judge, I will absolutely waive if you would allow me to get a bottle of water briefly.
Go right ahead.
Thank you, Your Honor.
All right, you're welcome. All right, Mr. Karasik, if you would like to provide testimony at this time, or if you'd like to call Ms. Smith as a witness, I'll let you proceed how you wish to.
I think I'd like to call Ms. Hart as a witness first, Judge, if that's okay.
All right. Go ahead.
Okay, so I don't need to see her. I can just ask her the questions that, oh,
You should be able to see her.
yeah, I guess I see her on the top. Well, I don't really, but I guess that's all right. If she can hear me, that's fine.
Are you using an iPhone?
No, I'm on a computer.
You should be able to switch your view so that you can see the whole room. However, if you have it on speaker, then you should be able to see the person who's speaking.
Okay, well, all right, Ms. Hart, good morning to you.
Good morning.
All right, I have a number of questions for you. I can see her now. Your affidavit indicates that you weren't aware of any problems on your own of any problems with the air conditioning unit. Is that correct?
That's correct.
Okay. Do you recall the November 6th pretrial mediation hearing that we had conducted over Zoom with the mediator?
Yes.
Do you recall talking about
Objection, Your Honor.
Sustained. Mr. Karasik, you can't ask questions about what took place during mediation.
Judge, you're going to have to maybe explain that a little bit to me. I understand that the mediation is technically, they say confidential, it's not recorded, but statement show something different. And so to not be able to elicit that testimony, let somebody, it just doesn't seem right. So I don't know why are you sustaining the objection? Why is it not admissible? Why can't I question her about what was said there? Since she's the witness, it was an open forum and it was an open court, and it wasn't an answer to a question, it was of her own free will. So maybe you could explain it to me a little bit more so I understand.
Mr. Green, would you like to respond?
Judge, mediations, including any statement made therein, are absolutely 100% confidential.
Correct, and that's pursuant to the Florida Rules of Evidence.
Okay.
Next question, Mr. Karasik.
Right. So, Ms. Hart, your claim is that you weren't aware of any problems with the design of the home, any problems with the unit itself during the time that you resided with your husband before his passing. Is that correct?
That's correct. A new air conditioning system was put in 2012.
Right. And also, and you did, I'm not trying to be personal, but there's a master bedroom, and you resided in the master bedroom with your husband during your cohabitation before his
That's
passing.
correct. And I never kept it at 80 degrees. I don't know where you got that 80 degrees from.
And your testimony again under oath is that you never felt a differential in the temperature between the master bedroom and the rest of the home. Is that correct?
No. There's
Okay.
fans in every room. No, I had
You-
no problem with the air conditioning in that house, with the
And
temperature.
and what temperature did you keep it at, if I might ask?
77 or 78.
Okay. And you submitted, well, after your husband passed away, you did have people come out for routine maintenance and also with a couple of problems with the air conditioning unit. Is that
Minor
correct?
problems, no major problems with the air conditioner.
Would you call no cool a minor problem, Ms. Hart?
Yes, but it was something that was repaired under warranty. It was no major repairs on that air conditioning system.
All right. And do you know how many times you called the company to repair it because it wasn't cooling the house?
Maybe 2 times, but it was just minor things that had to be fixed. No major repairs. They never told me it needed to be replaced again.
Okay, so according to your testimony, the air conditioning not cooling is a minor repair. That's
Yes,
what you're
because
telling
it was only a minor thing, a capacitor or a wire, something like that. No major. It was all under warranty. I never paid anything to have any of those any repairs done.
Well, I could look through the report things. I think there were some things, but you seem to be pretty good with the terminology there with the capacitors and things like that. So obviously you reviewed some of these invoices. Is that
Yes,
correct?
after my husband passed away, I was responsible to keep the air conditioning running.
Right. And so you signed those, you reviewed them, but you never had any discussions about why they had to come out a couple of different times. There was never
because
any.
there were never any major repairs had to be done.
Right. But the question is, were there any discussions with any of the repair people regarding the unit itself and how
No.
often it had been out there? Nothing.
They never told me anything needed to be fixed on it.
They never told you that there was a problem with the ductwork?
No.
And you never indicated that there was anything with the temperature differential, is that correct?
No, and I had family and friends come and stay, and nobody ever reported that they were hot in any of the rooms.
Right. Now, you submitted some some invoices or copies of your bank statement from Florida Power and Lights for, I guess, a couple months prior to us purchasing the home.
Absolutely.
And those were $200. One of them was a little less than that. And
186 and 226.
right. And were those standard bills for you? Or
Yeah.
was
Only in the summertime when the pool is on. Well, the pool's running all the time, but those were only in the summertime when it was hot. I never had any air conditioning bills that were over 226.
So if we were to get a history of your bills, even you're saying the summertime bills were the highest bills you had?
Absolutely, yes, in the summertime.
Okay, now when we there was a prior purchase agreement on your home, is that correct?
Right, and they had the air conditioning, they had the whole house inspected and they didn't find anything. You had 2 inspectors come because I was there and let them in. They told me they found no major things wrong with anything in the house, and that included the air conditioning. They were up in the attic. I was there when I let them in the house.
And did you have any access to can you tell us why the first purchase agreement fell through?
Yes, because the people that were going to buy their house, it fell through. Their agreement fell through.
So your testimony is that it had nothing to do with any inspections that may have been?
Absolutely not. Why do you think I had Whaley's come out and inspect the air conditioning? So I wouldn't run into any problems. And they came and inspected. They never said anything about any duct work or that anything needed to be replaced.
Perhaps you have offer an opinion. I'm sure your attorney will probably chime in here that that the day we moved in and turned the thermostat down to 76, that the air conditioning collapsed and we had a repairman come out.
Why didn't you call me that? You didn't call me until October to complain about the air conditioning. And then you sent me that thing about that it needed to be, you didn't send that until December. You didn't send that report that my husband had from 2013 until December. You called me in October of 2019 and said you wanted to talk about the air conditioning system. And I said no, because I wasn't going to let you harass me.
Yeah, Ms. Hart,
All those reports were on the counter. You saw them before you closed on the house, because I told you all the reports for the air conditioning system are on the counter.
well, you're under oath, Ms. Hart, and I'm not going to challenge that because it's not true. However, I will say this.
Object, Your Honor. Your Honor, I object.
All right.
What are you objecting to?
Do you have any more questions for Ms. Hart, Mr. Cruz?
I do. I have several more questions.
Okay,
Yes.
go ahead.
Thank you. I called you and
I
asked.
object, Your Honor.
I'm sorry.
He's testifying rather than asking questions of a witness that he's called.
I'll just rephrase it for you.
All
Is
right,
that
thank you,
right?
Mr. Karasik.
Did you receive a phone call from me sometime in October?
Yes.
And did I tell you or mention to you that we had a couple issues to talk about?
Yes.
All right.
You've already closed on the house, so it's your problem, not mine.
And that's pretty much what you said, but do you recall mentioning the air conditioning before I said anything about what the issue was?
No.
So if you were overheard saying that, then that person would be not telling the truth. Is that what your testimony is?
I don't know what you're talking about. Why do you think I had Whaley's come out? They checked the air conditioning system. You had 2 inspectors there. There was no problem with the air conditioning system before you bought the house.
Ms. Hart, I'm going to stop you. There's no question at this time. Mr. Karasik, go ahead.
Thank you. All right, so I asked you about when we moved in, the day we moved in, that the air conditioning stopped working, and we had to have somebody come out. Were we also aware that my power bills for August and September, the 2 months that we were there, were over $500? Were you aware?
I don't know what you were doing with the air conditioning system. You had my bills from June and July, 186, 226.
Are you saying that I had those bills before you sent them this time, or?
No, but why would you need them? I sent them to prove that I didn't have any high air conditioning bills. You never asked me how high my bills were.
Ms. Hart, I'm going to stop you. The question was, were you aware of what his bills were in August and September?
No.
Thank you.
Now, when we came to the home to look at it before purchasing it, were you living there at that time?
Yes, I lived in it until the day of closing.
Okay. And do you recall what the temperature was when we came to the house? Every
No.
time we came to the house? In
No.
your house? You don't know?
No.
So if I told you it was set on 80 degrees, would you dispute that?
Yes, because I never put it on 80 degrees.
Okay. So once again, Ms. Hart, if other people testify when they came in the home, the thermostat was set at 80 degrees, they're not telling the truth. Is that your
Absolutely,
testimony?
because I don't know who came in my house.
Well,
Who
other
came
than
in my
me,
house?
I'm talking about me, my wife, and our real estate agent, Mr. Tansky.
Well, you never said anything about it being too hot in the house before you bought the house.
So once again, so what you're saying is if there's testimony from other people that when we came in the house every time, which was at least 3, the thermostat was on 80 degrees, are you saying that's not true?
That's not true.
Okay. And so that's your testimony. All right. Now, if I could just have a moment, Judge.
Go ahead.
Do you recall, Ms. Hart, that, would be an interesting answer. Do you recall my wife asking you why the house was so warm and responding that you weren't staying there at the time?
No, because I told you, I stayed in the house until the day I closed on the house. And no, but you never said anything to me about it being too warm in the house.
Oh, honey.
Yeah, all right. I don't have any other questions at this time of her.
Mr. Green?
No cross, Your Honor.
All right, thank you.
I'll reserve the right to call her in my case in chief if necessary.
All right, so reserved. All right, Mr. Karasik, I don't know if you'd like to provide testimony, or if you'd like to call Ms. Smith as a witness.
I'll call Ms. Smith and then I'll testify, Judge.
All right, go ahead.
All right, you need to state your name for the record, please.
Nancy Carol Smith.
Okay, and you are married to me, is that correct?
Correct.
Okay, and we together went to the home prior to purchase at 930 Tropical Bay Court in Naples Waterways subdivision, is that correct?
Correct.
Okay, and when we were in the home, did you ever have any conversations with Ms. Hart regarding the temperature in the home?
I did.
And would you tell us what that conversation was?
I asked her why the home was so warm.
And what was her response to you?
She said she wasn't living there.
Okay. And did you have an opportunity, because the thermostat is on the wall, readily visible as you go through the home, did you see the thermostat, ever look at it to see what the temperature said?
I did.
And what was it set on?
80.
Okay. And every time, and I think it was at least 3 times we were in the home, did you, was it the same issue?
Yes,
As far as the
at
temperature
least
goes?
twice, and I did check the thermostat, and it was 80.
Okay. And do you recall when we had some conversations, you may have had a conversation when somebody was coming over to inspect, that we had to call her and let her know who was coming over because she wasn't staying at the home?
Yes.
Okay. So in other words, so she wasn't readily available. We had to ask her when we could come over so she could meet us there. Is that correct?
Yes.
Okay. Now, you heard me call Ms. Hart sometime maybe in October because we had found out the air conditioning was just beyond repair and needed to be replaced. Is that correct?
Yes.
And I called her and I told her that I'd like to talk to her about some issues that we had with the home. Is that correct?
Yes.
And did I mention what those issues were before she responded?
No.
And what was her response before?
Well,
Yeah.
I was sitting across from you on the couch, and I could hear her talking all the way across the couch. She was very loud, and she started talking extremely loud. It's where I could hear her saying things about the air conditioner and saying that this wasn't her blanking house anymore, and using a lot of very bad language.
Okay, and I don't know if you were able to hear her testimony or not. Did you hear me questioning her? Were you able to hear her answers?
Yes.
Okay, so you heard her earlier this morning say that it was your problem now, pretty much what she said at that time, right?
Yes.
And your testimony was that she mentioned the air conditioning before I had to ask any questions about what we were going to talk about.
Yes.
And my intention was to try to work something out with her at that time.
Yes, it was our intention. Yes.
But we never had a chance, correct?
No, we did not.
Okay. And when we went over there several times, we were also with our real estate agent, Jonathan Tansky. Is that correct?
Yes.
And he also had some conversations with Miss Hart.
Yes, he did.
Okay. But we can't talk about what that was. That would be hearsay. I don't have any other questions at this time.
All right, Mr. Green.
No questions, Your Honor.
All right, thank you. All right, Mr. Karasik, if you'd like to provide testimony, or if you have another witness to call.
No, well, Judge, Mr. Tansky was unavailable. I do have a phone number for him. I don't know. He could give testimony that would be in support of what I'm going to testify to and what my wife testified to. But unfortunately, I told him when the hearing was, and I think he had a doctor's appointment. I thought perhaps if I provided the phone number that you might be able to call him and put him on speaker, but I don't know. But I'll give my testimony now, and I guess we'll go from there. My name is Ken Karasik. I'm the husband of Nancy Smith. I'm the co-purchaser of the house at 930 Tropical Bay Court. My testimony is that every time, and I do mean every time we went to the house, we talked about how warm it was in the home. The thermostat was on the wall right around the corner from the dining room, and was always on 80 degrees every time I saw it. Mr. Tansky, which is why I called him as a witness, turned it down himself a couple of times, down to a livable temperature when you're in the heat of summer in August in Florida. Ms. Hart told me she was not staying there. There was very little furniture there. She had a cat, and she said she left food for the cat. The cat came outside. We were not provided with any documentation of anything prior to closing on the house and coming in to the home, moving in. She was kind enough to leave a couple pieces of furniture. She's, to me, seemed, nice. I mean, not overly nice, but but then the day we moved in, the temperature rose to over 90 degrees. I called somebody, they came in, court has documentation, they fixed something, I think it was $217. Well, things happen, we can't predict, so okay. So then 3 days later, it happened again, another $275. Well, what's going on here? And then it kept on going and going and going. And then we got the power bills that were over $500, which I did provide to opposing counsel for October. And we never used the pool heater. We never had the temperature below 76. And when we talked to Florida Power and Lights, they indicated that because of the lack of duct work, that the air conditioning unit itself was overworking to try to cool the house to the temperature that we wanted, which was really livable. And that's why the bills were so high, because it was overworking, it was overextended. And that's why we were having problems with parts failing at all times.
Move to strike any statement from FPL.
All right. Sustained.
Okay. Well, the bills speak for themselves. Suddenly, bills don't go up from $190 to $500 for nothing. So I did call Ms. Hart on the phone, as my wife testified. Just called and said, we've got some issues here, and I'd like to be able to maybe meet for coffee and discuss them. And she just broke out in
Objection,
anger.
Your Honor. He's discussing a settlement conference.
It's not a settlement conference. It's a conversation with.
It's a statement made in connection with an offer to compromise an existing claim.
I'm going to overrule the objection. Go ahead, Mr.
Thank you,
Grassley.
Judge. Right. Simply called her as a courtesy to see if we could fix things. You know, we don't want any trouble, didn't want to provide any trouble for her. And I never got to the issue. She immediately knew, to my mind, and started shouting about the air conditioner. And I'm not afraid to testify. She goes, "It's your fucking problem. That was a fucking money pit, and I'm done with it. So, you know, you handle it." And she hung up on me. End of story. So, I mean, what else can I tell you, Judge? I mean, I never mentioned the problem. My wife heard the conversation. She knew what the problem was. And so, unfortunately, we're not able to address what was said in mediation. I think the court can take notice, and I will suggest, whether you do or not, or whether it's appropriate or not, something occurred at the mediation hearing.
Objection,
Now,
Your Honor.
Sustained.
well, I'm not saying what occurred, Judge. I mean, I can't even talk about that something happened at the mediation. Are we saying I'm banned from even mentioning anything?
That's correct, Mr. Grassley.
Okay. Well, I filed a motion based obviously on something or on the hearing, let's put it that way. So I'm not mentioning anything. So, but it is kind of interesting that now the attorney that was at that hearing is not at this hearing.
Objection, Your Honor. Relevance.
Sustained.
Well, you know, I mean, you're tying my hands behind my back, quite frankly. I mean, yeah, I can tell you what the relevance is. The relevance is he may have overheard something.
Objection, Your Honor. Goes to confidentiality at mediation.
Sustained.
Client, attorney privilege.
It's, well, I think I've said enough in regards to, you know, I think we can probably read between the lines, these objections and things like that. So how does the court wish to handle Mr. Tansky? Or obviously he's not here. I can provide his phone number, but I don't know if that's appropriate or not.
Well, unfortunately, the rules of procedure don't allow for someone to testify telephonically unless someone is there that can swear him in.
I understand. Okay, well, we don't have any other witnesses, Judge.
All right, Mr. Green, any cross of Mr.
Yes, Your Honor. Yes, Your Honor.
Go ahead.
Sir, can you tell the court your occupation?
Right now, I'm a guest teacher for Collier County Public Schools.
Are you an attorney?
I was an attorney.
You were an attorney?
Yes,
In what state, sir?
Michigan.
When did you stop practicing law?
You know, I'm going to object to the relevance of this. I know where you're going, and but it's not relevant. So I'll object to relevancy.
Mr. Green, how's this relevant?
It's going to go to credibility, Your Honor.
Oh, not relevant.
All right,
Credibility is always relevant, Your
I'm
Honor.
going to overrule the objection at this time, but go ahead.
I stopped practicing law in September of 2017.
Why did you do that?
Well, because I had problems with the grievance commission, and I was suspended, and I decided I'd been in practice for 42 years, so I decided to retire. It was an appropriate time.
Were you not, in fact, disbarred, not suspended?
After I retired and was suspended, yes, I was disbarred because I did not return from Florida for a hearing on another matter. That why would I go back if I'd already retired and moved to Florida? So because I did not appear, they instituted a disbarment.
You mentioned suspension. In fact, weren't you suspended 10 times prior to being disbarred?
No.
What does that have to do with anything?
Nancy, be quiet. No, I was not suspended 10 times.
So if I were to provide the court after this hearing, report from the State of Michigan Attorney Discipline Board that shows 1 of 10, would you agree that, let me ask you this, would you agree that you had multiple cases that led up to this?
I would agree that I probably had more than 10 disciplinary actions, consent, reprimands, this, that, slaps on the wrist. Absolutely. No
Fair enough.
question about it.
Nothing further, Your Honor.
All right. Any rebuttal testimony, Mr. Karasik?
Yeah, just a little bit. I speak my piece. I was an attorney for 42 years. Obviously, Mr. Green probably doesn't handle criminal cases where you're dealing with murderers, rapists, sexual predators, thieves, drug addicts who, have to have somebody to blame. And when you have a body that, takes everything, and you have to answer in triplicate, I handle my cases the way I handle my cases, and I probably rubbed a lot of feathers, and I probably didn't take a lot of orders from people who sit on the grievance commission and have never been in a courtroom themselves. That being said, this to suggest that my history as an attorney would cause my credibility in regards to an air conditioning unit, which obviously we've provided lots of documentation that it didn't work, that it had to be replaced. So that isn't even in question, really, whether the air conditioner was working or not working. To me, when Ms. Hart can complain about me saying she's hiding behind her husband's death, which I think she is, quite frankly, to talk about my credibility from 5 years ago, I'm talking about an air conditioning unit is really, I think beyond but I'm not surprised.
Your Honor, may I say something?
No, Nancy, please be quiet.
Ms. Smith, Mr. Karasik is testifying.
Yeah, it's okay. It's okay. So, but I think, and I hope the court can view this. I know you're a fair and equitable person. I know that. And I understand your hands are tied. I really feel like my hands are tied because there's no question in my mind, and I'm sure there's no question from anybody else, that things that were said at another hearing appropriately.
Objection, Your Honor.
I said another hearing. I didn't even mention it.
Judge, there has been no other hearing.
Well, at another session, I don't know how you want me to phrase this,
Sustain the
would probably.
Mr. Karasik, are you still there?
That's unfortunate. But I think we have provided enough evidence from my wife, who's honorable, and I don't think you can attack her credibility, and myself, and unfortunately we don't have Mr. Tansky here, to show that that there was certainly reason to believe that Ms. Hart was aware there was an issue. And again, we have to look back at what the things that she said. The as-is contract is not dispositive. It's not an excuse under Johnson v. Davis. The Whaley's thing is simply operating at that time. Again, what's the definition of designed to be? Designed to me means cooling the house, and it wasn't designed, it wasn't cooling the whole house. So to believe that nobody knew about an 8 to 10 degree differential when every single person that came out there estimate said the same thing is pretty hard to believe. So I think that we have proven a prima facie case that she was able, she was aware of it. She could have checked the box, I don't know, as far as the air conditioning, but she chose not to. And she obviously has issues. Her statement that she was living there has been disputed by myself and my wife. And so I guess I have to leave the decision to the court and live with it at this time.
All right, thank you, Mr. Karasik. Mr. Green, anything from you?
Yes, Your Honor, I would move for a directed verdict in favor of Ms. Hart. he just summarized his case as telling Your Honor that there is, and I quote, reason to believe that Mrs. Hart was aware of an issue. As you're aware, Your Honor, Johnson v. Davis requires actual knowledge. There's been no evidence of any actual knowledge by Ms. Hart. In fact, Ms. Hart has testified, Your Honor, that she had no knowledge. The invoices that are presented to the court do not prove that she had knowledge of any problem. In fact, they show that perhaps there was a design issue with regard to the air conditioning ductwork, which was consistent with the disclosure made at the time of closing. Above and beyond that, she wasn't even aware that that existed, however, Your Honor. You know, the credibility issue and the reason that I went into the area that I did was proven. I asked him, why did he stop practicing law? And his testimony under oath to Your Honor was because he was suspended. Your Honor, he stopped practicing law because he was disbarred. He attempted to hide that from you. I didn't know if I was going to be able to go there until he testified the way he did. I'd leave it at that. If Your Honor would grant the motion for directed verdict, Ms. Hart has testified to most of what she would testify to on direct. My only evidence, in addition to her testimony, are the 4 exhibits that were filed with my exhibit list, number 1, 2, 3, 4. They include the contract that includes the disclosure at issue that's attached to plaintiff's complaint. They include the 2 electric bill summaries from bank statements, those amounts that were testified to today. They include the invoice from several months prior to closing, Wayland's that indicates operating as designed, and I would have no other evidence to present than that in my case in chief.
Your Honor, may I say just one thing? He got married, and that's why he stopped practicing law. He came to Florida and came to live with me.
All right, thank you, Ms. Smith.
I'm
Judge-
sorry. Thank you.
Judge, one other thing, since it is our case, I just want to respond briefly.
All right, briefly.
Yes, very briefly. You know, it's almost humorous. The other attorney saying, "Oh, my credibility." No, he asked me why I stopped. I retired, and I did. I said I was suspended, and I was not disbarred till a year after I was living in Florida, and I told him why. And not only did I tell him that, but I told him about 10 suspensions. I denied that because there weren't 10 suspensions. But as far as disciplinary actions, there was way more, and I told him that. I'm not hiding anything. I'm proud of what I did as an attorney. But when you deal with that kind of clientele, you take the chances, and that's how it works. So, you know, it is what it is. But again, I stand by our statements in regards to what happened at the home and what was regards to the air conditioning. Thank you.
All right, thank you. All right, give me one moment. I'll be back with my ruling.
Thank you, Your Honor.
All right, do I have everyone back with us?
Yes.
All right, everyone is present. All right, having heard the testimony and received the evidence in this case, the court finds that the plaintiff has failed to prove that defendant had actual knowledge of a defect in the air conditioning ductwork as alleged in the statement of claim, and therefore there was no proof that the seller failed to disclose anything regarding the air conditioning unit to the buyers. Accordingly, the court finds for the defendant, and the plaintiff shall take nothing by this suit, and defendant shall go hence without delay.
Your Honor,
Yes, Mr. Green.
we have a claim for attorney's fees pursuant to paragraph 17 of Exhibit 1. The contract provides for the prevailing party to recover their attorney's fees.
No.
We pled it, and we pled it in our answer, Your Honor. And I would ask that you reserve jurisdiction as to the amount.
All right, jurisdiction as to the amount of attorney's fees are so ordered reserved.
And costs, Your Honor.
And costs, yes.
Thank you, Your Honor.
All right, thank you, everyone. I'll issue my written order probably later, hopefully this afternoon.
Thank you, Your Honor.
Just for the record, Judge, we would object to any attorney fees or costs despite what the ruling that he cited may have said. Just for the record. All right, thank you.
Your objection is noted.
All right, thank you.
All right, thank you, everyone.
All right.
All right, Tommy, I'm going to go ahead and bring in the parties for the next case, and then we'll take just a brief recess.
Okay.
All right. All right, good morning, everyone. I'm Judge Blake Adams. We're here for the small claims non-jury trial docket for the 10 o'clock docket. The case we have on the 10 o'clock docket this morning is Christopher Michael Lewis and Jessica Lewis v. ESK LLC, Ralph Epifanio and Michelle Bauer. I'm going to take a brief recess. I apologize. The last case ran a little bit long. The clerk and I need to take a brief recess, and then we'll come back and start. All right. Thank you, everyone. We'll be right back. All right, good morning again, everyone. Again, I'm Judge Blake Adams. We're here for the small claims non-jury trial docket this morning. The case we have again before us is Christopher Michael Lewis v. Jessica Lewis. Christopher Michael Lewis and Jessica Lewis v. ESK LLC and Ralph Epifanio and Michelle Bauer. Case number 20 SC 2869. Based on the statement of claim, it appears that the plaintiffs are seeking portions of the security deposit from the landlords. Let me just make sure if I could have the plaintiffs unmute themselves and announce themselves for the record.
Yes, Your Honor. This is Christopher Lewis, and I am present.
Thank you. And do we have Jessica Lewis present?
No, Your Honor. I'm sorry. She's at work today.
All right. And then who do we have representing ESK LLC?
Ralph Epifanio.
All right. Thank you, sir. And what is your position with the LLC?
I'm the managing partner.
All right. Thank you. And then it looks like we have Michelle Bauer present.
Hi there, Michelle Bauer.
All right. Thank you. And then looks like we have a couple of other people in the courtroom. Are those witnesses?
Joe Epifanio, real estate agent.
All right, thank you. And Georgiana Portilla. Anyone know who that is?
Your Honor, I think she's here for the 11 o'clock.
All right, I'll go ahead and put her back in the waiting room then. Okay. Before we begin a small claims non-jury trial, I like to provide a little bit of information, especially considering no one here today is represented by an attorney, and let you know how a small claims non-jury trial works. Each side will be able to present their testimony and physical evidence. Plaintiffs will get to go first. You'll be able to testify or to call any witnesses that you may have, present all of your evidence. The defendant will have an opportunity to cross-examine you, and then you'll have an opportunity to provide any rebuttal evidence or testimony. Same thing with the defense side. The defense will go next. You'll be able to present any testimony, witnesses, or evidence that you have. The plaintiff will be able to cross-examine or question those witnesses or yourself if you're testifying. And then each side will have an opportunity to present a closing argument as to why the court should rule in their favor. One last thing I'd like to ask, and the reason I ask that is because many times when people go to small claims non-jury trial, neither side comes out very happy. And that's because while I may rule, or while the court may rule in favor of the plaintiff, it may not be for the entire amount that they're requesting, and thus the plaintiff walks out unhappy because they didn't get what they wanted. Or it may be because I rule in favor of the defendant and the plaintiff gets nothing. On the other hand, it may be that I rule entirely for the plaintiff, and then of course the defendant walks out unhappy. So with that in mind, Mr. Lewis and Mr. Epifanio, would you like an opportunity to speak privately to try to reach a settlement in this case?
Your Honor, I have communicated with the defendant multiple times and shared all evidence that I have with him, and all efforts to come to a reasonable conclusion. And so far they have failed, but yes, if the defendant would like to talk one more time, I would be all for it.
All right, Mr. Epifanio. Am I pronouncing your last name correctly? I'm sorry.
It's Epifanio.
Epifanio.
Pretty close. Your Honor, we did talk, and I made a financial offer to settle, and he turned it down. And so, you know.
Would you like one more opportunity?
No, I don't think so. I think at this point, no matter what I offer, he didn't want to settle. He wanted to go for the whole thing. So I said, let's go. As long as we're here, let's go.
Okay. Now, let me, before you announce you're ready to go, Mr. Epifanio, let me note that I see that you filed a letter to the court. In the letter, it states, I have attached all evidence regarding my claims. However, there's nothing attached to that letter. You're on mute.
I gave the clerk at the court, when I went in, he scanned everything. There was a whole bunch. I've got a whole 3-ring binder of this stuff. The only thing he told me I couldn't put in was the pictures, because the pictures wouldn't scan.
Okay.
But
what date did you do that on?
There was probably about 40 pages.
All right. What date did you come in to do that?
Oh God, I think it was last Monday. Probably the same day you would have got the letter.
Okay. Tommy, do you see anything in the court file for that?
I do. In showcase, it is docket line 25.
All right. Is that 50 pages?
No, sorry, that's from Chris Lewis. No, I don't see anything from Mr. Epifanio.
I don't either. All right. Give me one moment. Let me check with my judicial assistant to see. Mr. Lewis, you filed exhibits also. Is that correct?
Yes, sir. I filed a couple pages, and then Ralph sent me some pictures and stuff, and I was actually going to use that picture evidence for my argument, sir.
Okay. All right. Let me check with my judicial assistant and see if perhaps the clerk provided Mr. Epifanio's documents to her, because sometimes if it's a voluminous amount of evidence, they'll provide it to our office instead of scanning it into the file. All right. So I'll be right back. Tommy, are you still there?
Yes, I am.
I have an email from, or my judicial assistant has an email from Mr. Epifanio regarding a 3-ring binder, which he just talked about, that he brought to the clerk's office to be scanned. Can you check with someone there?
I did. I checked with the supervisor while we were on recess, and we don't have anything up here.
Okay. All right. And Mr. Epifanio, we only have, Julianne, do you have those? The only pages we have of that are the ones that you emailed to her, which includes a letter to the plaintiff, which looks like it's a notice to impose a claim on the security deposit, and then a copy of I believe it's a lease extension. And maybe a invoice as to the security deposit charges. I don't know what else you filed.
I filed all the receipts for all the things that I'm claiming. I filed all the pictures that went along. Well, she wouldn't let me, or he wouldn't let me do the pictures because he said they wouldn't scan. So I have pictures of all the damage, and I have, my witness, one of my witnesses, Joe Epifanio. He's the realtor that handles my rentals.
Okay.
And
how many pages would you say were included?
I would say there's about 40. Well, less the pictures, I'm sorry. So probably about 15, less the pictures.
So about 15 pages plus 25 photos.
Yes.
All right. I don't know why the clerk doesn't have them. My guess is if we want to have a trial, you would like a continuance so the court will have that evidence.
Yes.
Okay. I'm looking at my calendar here. And you provided copies of all of those to the plaintiff?
Yes, I did.
Okay, Mr. Lewis is shaking his head yes. Okay. All right. Mr. Lewis, do you have any legal objection to the defendant's request for a continuance?
No, Your Honor, because I would actually like to use the picture evidence as benefit for my argument. So
Okay.
I am okay with that.
Okay, so we can do this. We can do one of two ways as far as a date goes. My next regularly scheduled small claims non-jury trial docket is February 17th. Or if for some reason that date doesn't work for the parties or your witnesses, I could have you coordinate a date with my judicial assistant. I'll start with Mr. Lewis since he's the plaintiff.
Yes, sir. I should be available on February 17th. I work from home, so my schedule is pretty flexible.
All right. Do you prefer mornings or afternoon?
Mornings would be best while the kids are at school, so it'll be quiet.
All right, Mr. Epifanio, what do you know? I don't know if you know your witness availability yet for February 17th.
The 17th is fine for me, AM.
All right.
Depends on Joe and Michelle.
Okay. Let me look to see what I have on the 17th so far. So far, I only have one on the 9 o'clock. 10 o'clock, same time, okay for both of you?
Yes, Your Honor.
Yes, Your Honor.
Okay. Tommy, let's continue this to February 17th at 10 a.m. I will send out an order this afternoon that will provide you with the Zoom login information for that one, and because it'll be different than today's. And then, do we have email addresses for both of you?
I believe you do, Your Honor. I have communicated via email with your assistant.
Okay. All right. And same with you, Mr. Epifanio?
I think you should, yes.
Okay. All right. I'll get that order, continuing it with the Zoom information to February 17th. Now, Mr. Epifanio, what I'd like for you to do is, instead of trying to get those exhibits filed again with the clerk, I'd like for you to make a copy of your binder with all the photographs that you've already provided to Mr. Lewis, and drop those off here at the courthouse for my attention.
I can do that.
Okay. And you can do that on the 5th floor of the courthouse. It's court administration.
5th floor, okay.
And just make sure to put the case number on it and that it's for Judge Adams. And then I'll have those here in my office for the February 17th trial, and anything that's admitted into evidence, I will just provide to the clerk and those will get scanned.
Great.
Okay?
Thank you.
All right. Any questions from anyone? I apologize that we couldn't go forward today.
No, Your Honor. Thank you very much for your time.
All right. Thank you, Mr. Lewis. Thank you, Mr. Epifanio, Ms. Bauer, Mr. Epifanio. All right. Thank you. Have a good day. All right. Tommy, I'll let Julianne know of what we're doing in this case and that he's going to be dropping that off for us.
Okay.
I think when it's that many, they probably should just drop it off to us, because who knows what's going to get admitted.
Right.
Okay. Next case is at 11, so we'll be in recess till 11.
All right.
Okay. Thanks, Tommy.
Thanks.
Bye. All right, it is about 10 after 11, and I've got Ms. Portilla here. I do not have Mr. Barahona present, so we'll go ahead and we'll consider Mr. Barahona in default. And Ms. Portilla, I'm looking at your statement of claim, and there are no documents attached to it as to evidence why Mr. Baharona, why you would be entitled to $8,000 from him. Do you have any contracts or receipts that you would like to provide the court?
Yes, I do, Your Honor. And actually, I sent an email yesterday. It's actually in the morning when I got the letter for code from my neighbor. It was delivered to him by mistake. So, I kept on calling the court and they told me to wait for the letter. And it's only yesterday morning when I received this letter. Now, the contract that I have with him and the receipts and everything, obviously, because of the language, it's all in Spanish. So I wonder if you would have for me to get that translator, or what do I need to do? And obviously, all I'm asking, I'm a real estate agent, and he told me that he had a big experience in building pools, that he did it in New York, but I found out it was all lies. So I refer, few customers to him, believing in his word. And at the end, I have two that were able to actually submit small claims as well, because he didn't finish the pools and he just disappeared. He turned his phone off and never answered. And I know that there is others that they don't know how to file a small claim or do anything. So, that's what I'm kind of more concerned about, is other people that are not able to come, forward and say something.
Okay. So you said the receipts that you have are in Spanish?
Yes, everything I did with him, because he's not, like a well-established company. I think he has a corporation, but he doesn't really have receipts in his hands or anything. Obviously, I wanted to have something, so everything he gave me was in Spanish.
Okay.
So that's what I have. Obviously, there is the blueprints and everything, which I'm afraid that I was already told by a plumber that I'm missing a big important part that I sent on the email as well, that I begged him to please show me where it is. It's called a skimmer for the suction of the pool and all that. A kid can be trapped in the bottom of the pool, and the architect told me that it was supposed to be there, but it's not. So.
Well, so you're claiming $8,000 in your statement of claims. So what I would need are receipts or contracts showing, that is what he owes you. As far as the plans for the pool, those aren't really relevant at this point since he is now in default. So what I'm going to do is give me one moment. So I'm going to do an order setting a hearing. I'm going to find the defendant in default for failing to appear. And then I'm going to do an order setting a hearing, setting an evidentiary hearing as to unliquidated damages for you to bring in those receipts or canceled checks or contracts, whatever you've got showing your amount of claim, how much you should be awarded. Let me look at my calendar here. And if they're in Spanish, you will need to get those interpreted.
Okay.
Let me see when my next hearing date would be. I have February 17th or February 18th.
The 18th is good.
The 18th?
Please.
Any particular time you prefer?
The morning is fine, if it's okay with you.
Okay. Let's go with February 18th at, do you want 11 or do you want earlier?
11 is perfect.
Okay. All right, February 18th, 2021 at 11 a.m. I'll do that order today. And I know that we have your email address because I saw that you emailed my judicial assistant.
Yes.
And we'll get that notice emailed to you this afternoon. And then just make sure any documents you plan to present to the court, make sure you file those with the clerk and send my judicial assistant a copy of those.
I will.
Okay, any questions?
No, Your Honor. Thank you so much for your time.
All right, thank you, Ms. Portillo. Stay
Have a
safe.
great day. Take
All
care.
right, you too.
Bye.
Bye. All right, Tommy, any questions?
Nope. I will see you tomorrow.
Okay, what do we have to